Good morning, everybody, and welcome back to Money in the Law with Jay Marsden and John Droin on MyFM 101.3, your favorite morning show on Saturdays from 9 to 10. Jay, he brings you everything that you ever want to know about law, legal matters, or anything that has to do with the Constitution. I mean, anything. And I'll just talk to you about money, which obviously is more important to most people than
people love the Constitution, but they love money, and if the if they like the way they come together, but.
Well, would they buy the Constitution? I don't know.
It depends.
It depends how much what the price is.
These days, it's going up and up. It seems to be costing quite a bit. Some people would argue that it's becoming a little unaffordable. I don't know.
The Constitution is never unaffordable. The Constitution, I have to say that I lean towards the Constitution. I would, even though I think money is important. Money isn't everything. You heard
I believe we've both taken an oath to defend the Constitution.
You are correct.
Which I will gladly do 7 days a week, 24 hours. Happy to do it.
You heard it from your financial planner here on the radio and on Hollis & Cable Access TV. It's only money, right?
It's only money.
Is it more important than the Constitution? Obviously not.
It's only money. It's only freedom. Both important. We talk about both on this show in a different capacity.
Not more important than freedom.
Never.
All right, so
nothing's more important.
What are we doing? We're talking about the Constitution?
I don't know. Talk about the founding fathers' approach to the Constitution.
Don't even start.
Talking about being an originalist. Are you an interpreter? How do you see it? Is it a living, breathing document? How do you say it?
Over the break, guess where I was?
Philadelphia.
No, I was close. I mean, you'd think that because of the Constitution. I was in the next best place, our nation's capital, Washington, D.C.
Yeah.
I went back and we did it. So last year we went with the school, right? Yep. So I went with the school as one of the chaperones, a little different. Yep. This year we went and Haley got to go. So we did another review, and I got this. That was last year was my first time in the Holocaust Museum. So and you and I have talked about this before. So coming in at the second time, because the first time you go in, for those of you who haven't been, it is an absolute must visit. Like you have to visit it, and it is it's an all day event, and it's one of those things that
it's an all day event, and it's an all senses event.
Yeah,
it's an unbelievable experience.
So you'll come out of there with, I mean, it's incredible how all of the things that you're going to learn. There's so much to take in, and even if you're there for 6 hours, it's so overwhelming in so many ways that it's hard to kind of get it all and retain it. So going back the second time, I was able to kind of focus on some of the things that I really didn't get to, that I kind of glossed over in the beginning, because particularly the history of it and how and I always talk to my father-in-law. So my father-in-law was born in 1938. Sorry, I'm giving away your age on the radio. Yeah. So, but he grew up in England, and he was a kid. He remembers the war. He remembers the Blitz. He remembers the bombing. He remembers having to move from London to the country because London was getting bombed. So he grew up in that, and so in his lifetime this happened. So I always say, it's amazing to me that something like this could happen in Europe, in modern Europe. Where to like the kids, it's a million years ago. When you talk about World War II, or you talk about the Civil War, you talk about the Revolution, where they're all the same. They're all, wow, it happened so long
time ago. That's
but it really wasn't that long ago. So that was the thing I took away from it. It was just the kind of how fascinating, how fast it all took place, and before you knew it, it was the war was upon us, and all that was happening, and then the horrible result of. Which ended up being the Holocaust.
Yeah, no, I agree with you. And even if you fancy yourself a bit of a student of history, that museum, the experience you have going through there, the things you learn, the way the museum's laid out, the information that's presented to you, how it's presented to you. I mean, it's an unbelievable experience. I don't say it as a positive. I say you look at it and you say to yourself, I'm so much more informed about that time in world history. Right. And the impact that an event like this had. And it is, I had the good fortune of going down to D.C. with my old man, and we did a weeks-long trip down there, and we viewed it as the read the little letters on the plaques tour, because nobody wants to do the same thing that we wanted to do, which is to spend 6 or 7 hours per museum, which is what we did. I mean, we went to American history one day, we went to the Holocaust one day, and literally walked through it at a snail's pace and took it all in. We weren't rushed. The kids weren't bored. I mean, it was just him and I. And it was an unbelievable trip, unbelievable way to do it. But unbelievable trip, and I'm glad you guys got a chance to experience it.
Well, and one of the things that I'm sure that you and your father did that you wouldn't have got to experience if you had gone on the field trip with the 8th grade middle school field trip is some of the restaurants and some of the things that you can do at restaurants after you go to the museum.
Well, we did a lot of that. Yeah, we did a lot of this.
Which I did this time, which I didn't get to do last time.
Yeah, it's a different view. It's a different view of the restaurant scene with 80 8th graders as opposed to what you're going through.
Right, when you're going to Cracker Barrel or when you're going to the Golden Corral with 172 kids, yeah.
And you're going to pull their face out of the chocolate fountain because they're literally treating it like a, like a bob in the, yeah.
I was more happy with the fact that I got to get a pitcher of margaritas with this foamy salt thing that I got to put, and which wasn't available to me as a chaperone on the field trip. But all for all the right reasons.
True patriot right there.
For
True
all
patriot.
The right reasons.
That's right. So what are we talking about today? What's on your mind?
Before we're talking we're talking about. I don't know if we've properly introduced Christian. Christian again is here with us today for Hollis and Cable Access TV. Christian makes it all happen, and I as a board member of Hollis and Cable Access, I get to see kind of behind the scenes. I get to work with all the great people down there, and just so you know, I don't want to say this in front of Christian because I don't. So Christian, just kind of block your ears. They think he's doing a great job down there.
Nice.
And so I want him to make sure that I want like our listeners to know that he's
doing
but
don't let him know that.
I don't want him to know, and I don't want him to get his head too big. I mean, his headphones, they barely fit anyway.
Nothing says take your foot off the gas like hearing you're doing a great job.
No,
to his generation.
That's right. Yeah, that's like, oh, good. I'm close to retirement.
Of course, I'm doing a great job. Everybody gets a trophy for participation. Of course, I'm doing a great job.
I have 2 cameras working right now.
That's right. That's good stuff. Good stuff.
So what do you want to talk? I know what I want to talk about.
I want to hear this one. Go ahead.
It has to do with the law.
Oh, even better.
So in practice, in our practice lately, and I don't know what it is, but lately I've been having these kind of back to basics conversations about trusts. So a client will come up to me and they'll say, hey, you know what I just did? I called, I haven't talked to you in 4 months, and in the meantime, I called a lawyer who you don't know, and they just said I needed to put this money into a trust, so I did. I'm in the process, and I'm about to sign this trust, and I'm like, stop, right? I'm a non-practicing attorney who did not go to law school. However, I know a thing or two about these things.
Yep. So, by osmosis.
Yeah. Yep. So, well, actually, by osmosis, and the fact that I work with a guy.
Plus, and you have an intern in your office who spends a lot of time working in our office as an intern down here with us.
So
she brings a lot of that legal. So that's almost like having a lawyer in your office.
Exactly.
That's right.
So my clients are like, they seem to have kind of lost, and they truly don't understand kind of the difference between what a revocable trust does and what an irrevocable trust does, and what the value of each one brings, and why I use one in one situation and why I use another. So I find myself 3 separate occasions, I've had to kind of go back and say, okay, let's start from the beginning. What's your intent here? What is the purpose of what do you want to accomplish? What's the end state? When all the dust settles, and then work our way backwards. So I don't think it would be a bad thing unless you had something better to.
Oh my God! First of all, you're bringing a tear to my eye.
I don't think it would be a bad thing.
Just the ability to talk about this.
Say, and for our loyal listeners and loyal viewers who have been watching the show and following us for the past almost 6 years now. We've talked about this before. We talked about this more than once, more than twice, more than I don't know how many times. But I think it might not be a bad idea to let's do a review of some of the basics. Like, okay, what is a trust? Because trusts are great things, right?
Oh yeah.
They solve a lot of problems. They organize things. They can put you in a position where your estate plan is exactly the way you want to leave your legacy. And they're incredible instruments, but they have to be used in the right way. They're not free, right? So that's the other thing is people will be like, well, my lawyer said I need a trust. Okay, well, your lawyer says you need a trust. Let's talk again. It all starts with what do I want to accomplish? What do I want to get out of this? And then we'll see if a trust is the answer and if it makes sense and what's the right kind.
Oh, well, we could talk about that all day long. Matter of fact, we do talk about that all day long down at the firm. Yeah, that's one of our talking points.
Did you call it down at the farm?
Down at the firm. Down at the farm.
I was going to say
the farm, where we're farming trusts. That's right. We're farming for clients all day long, helping them grow their wealth.
And all right, so let's talk about that. Let's talk about, say, what is it? What is a
so we'll start with the basics, and we'll start with the easy one, right? Which is the revocable trust. Now,
so easy.
Lawyers, of course, being lawyers, they like to have lots of names for the same exact thing. Why? Because it makes us seem wicked smart.
Wicked smarter.
Right? So we like to interchange the words to confuse everybody so we look like the smartest people in the room. That's what lawyers do, right? So we talk about a revocable trust or a living trust or a family trust. Those are all, for the most part,
same thing.
The same thing. All right, so we'll go with revocable, not revocable. I like the revocable. I tend to
well, then you kind of know what you're saying.
That's right.
There's a little more enunciation.
Yeah, revocable sounds like I'm kind of like hicking up during the meeting, right?
Yeah.
So yeah, that's right. So it's a revocable, right? Which means you can change it, right?
I mean, you can revoke it.
You can revoke it.
Yeah.
But here's the thing that we try to, when we lead off with the trust discussion, this is the way we try to simplify it, okay? We try to simplify it by saying all you do with a trust is you take the same exact wishes that you would normally put into your will, right? Everything to your kids, for example, right? And you just put that language in your trust, all right? And now you have created a blueprint that says anything that's in my trust, and we'll talk about this in a second, anything that's in my trust, the trust document governs what happens to it, okay? Now, the analogy that I'll make is you have an IRA. Your IRA has somewhere, hopefully, a piece of paper that's been filled out and signed by you that says, if I'm not around, these people get my IRA.
These lucky people.
These lucky individuals get my IRA. And what that means is something happens to you, they're going to pick up the phone, they're going to call you at Main Effort Financial, they're going to say, my mother passed away, she had a big IRA with you, and we're the beneficiaries, and we would like to get that money. And then you will look at the paperwork and say, well, you know what? That's exactly what the beneficiary information says. So let's make arrangements. Here's the Main Effort paperwork that you have to fill out to get this money. A trust does the same exact thing for non-retirement assets, assets that would not normally have a named beneficiary listed on them. Things like real estate, things like investment accounts. And we've talked about this on the show before. Investment accounts that are not IRA, that are not 401k, that are not annuity, because those all have a beneficiary on them. This is for taxable money.
Well, simplify it even more, right? It's your stuff, right?
Yeah.
It's your. So when we talk about property, right? When the lawyers talk about property, it's anything. It could be your house, it could be your cars, it could be your money, right? That's all your property. So so as Jay said, the money in my bank account. My bank account is my property. It's money. There's no paperwork that says if I die that my bank account goes to, unless it's a joint account, right? We can talk about that. But if I have an account just my own, if I die, that becomes part of my estate. That becomes, unless there's when my estate paperwork or my probate paperwork or my will says everything in here is going into this trust. And one of the ways,
and by the way, and that's for the most part, if you have a trust, that's all your will is going to say. Your will is going to call a pour over will, right? Everything pours over into your trust.
Write all this down,
right?
folks.
Right?
Write it down.
Basically, all your will says is, hey, by the way, if there's something that I didn't think ahead of time to put in my trust, you, Mr. or Mrs. Executor, put it in my trust. And that's just, and remember, your will is a public document, right? So if this thing has to get pushed off to the probate court, any jamoke in the world can walk in off the street and start looking up probate files.
And there's jamokes out there.
And so then they're going to see, oh, this is where
probate jamokes.
This is where this is
pro jokes.
This is what Marsden wanted to have happen to his stuff. Well, instead, all your will says is, give it to my trust, and then that's really where the magic happens, and that's private. That's nobody's business but you as the maker of the trust and the people who are the beneficiaries of your trust. And as John mentioned in the beginning, all of this is done in a way that gives you total flexibility and control. You can change anything at any time.
Okay, so this is what I want to do. Let's take a quick break. All right, so what have we learned right now? So far we've learned that we pretty much put anything and everything into this trust. When everything can be put into this trust, with the exception, what people will not do is you won't have anything that has a named beneficiary
Correct.
go into the trust. Now, we'll talk about that's what can go into the trust. So think of the trust as like, the way it was described to me as a box, right?
Oh, yeah.
Yep. So think of it as a great big giant box that you can put your stuff in, all right? So when we come back, we're going to talk about kind of the makeup of a trust, kind of the main players of who is involved in the trust, and how those main players, like what their particular roles are, or how they're affected by this whole trust estate plan. So again, we're talking about revocable trusts. We'll talk about that when we come right back.
Very exciting.
We'll be right back on My FM 101.3, Money, and the Law. Money and the Law.
The law.
We'll be right back.
And we're back. Money and the Law, My FM 101.3. He is John Drohan, Main Effort Financial. I am Jay Marsden, Marsden Law Group. Christian, man in the con, keeping us skinny and handsome on HCAT.
Can you drink water on TV?
No, just bourbon or scotch. Any of the whiskeys.
You're not allowed to drink on TV.
Any of the whiskeys. It's fine.
You're not allowed to drink in commercials.
No, I know. That's why I don't watch TV. That's why I don't take part in any commercials. None.
But you used to do that. I mean, you used to drink on TV.
We did. Way back in the day. We did.
And you know who was behind the camera then? Don Cronin.
Don Cronin, the barbarian. Yes.
We're not throwing him under the bus, but I'll tell you what. Again, every now and again we get a little reminiscent about the old days, right? You know, and that beer tasting segment, that was some vintage television.
Oh, fantastic.
Vintage.
Good as it gets, as good as it got. And by the way, I'm not gonna lie to you, it led to some very unproductive Saturdays for yours truly, because I come home from the radio show and
you were productive.
My wife would say, "How was the show?" And I'd say,
like, "I'm
"It was
exhausted."
great, and I need a nap. It was fantastic. It was awesome. It was great. Yeah, it's good stuff. It's good stuff. Good stuff.
It's good stuff.
So prior to the break, we're talking about trusts. We're talking about the revocable trust, the trusts that are revocable. And we were talking about coming back to talk about who the players are.
Yeah.
This is where it gets interesting, because everybody mixes this part up, right? And here's
Thank God there's an attorney here to
make it all clear. That's right. To make it clear with big long words.
Clear it up.
So here's where it gets weird, right? There are essentially, think of it like a triangle, right? There are three parties to a trust for the most part, right? There's the donor, or of course we talked about multiple words for the same thing. Donor, grantor, maker, okay? It's the person who establishes the trust.
Yeah.
Okay.
In our practice, we say, this is the guy who makes a trust.
Yep, that's right. That's right. Very straightforward,
yeah.
right?
Like, this is my trust.
You're the trust
putting the stuff. I'm the one putting the stuff in. Yeah.
Right.
I'm filling the box.
Right. So it's your trust. You set it up. All right. Then there's the back end. Right. The back end is the beneficiaries. Who is the trust ultimate beneficiary? And the way we explain it is, you're not around. Who gets your stuff? Okay. Now, here's where it gets weird. Okay. While you're alive, while we've talked about this changeability and the ability to revoke the trust, you may wear more than one hat. Okay. So you're the person who made the trust, and while you're alive, you could also be the beneficiary of the trust.
How is that, Jay?
I know. It's magic. It's
How does that
legal
happen?
magic, right? It's your stuff. You're putting it in there, and you are the one laying out
But I
the
died.
rules.
How can I get it?
All right? But you're not dead. You're alive. So while you're alive, well, use some money. Put some money to it. You put $100,000 in your trust. You made the trust, and you say in the trust, while I'm alive, I can use my 100.
That's
right. That's all you're saying. Okay.
I can benefit. I can. Right. That and the specifics inside the document say I can do that.
That's right. That's right. And anytime, by the way, anytime somebody calls us up and they say, I have a question for you. My mother, father, aunt, uncle, grandma had a trust, and I have all these questions. We usually say, stop right there. Right. Just like meatloaf. Stop right there. Right. We say, whatever you want to know, whatever answers you seek.
Just
okay.
like meatloaf.
I like that. Any answers you seek, we're going to look to the trust to tell us those answers, because the answers to all the rules of how the trust needs to be handled are enclosed in the four corners of the trust document. Okay?
That's the beauty of it. That's again, so back to how in Main Effort Financial, when we try and dumb this down, we say, look, there's a box. Inside the box, there's an instruction sheet, right?
There's a manual.
Right, and it says, okay, it says, hey, what's in the box? Look at all this stuff. And then it'll say inside, then the instruction sheet says specifically, very specifically, as specific as you want to make it, this is what happens with all this stuff. This is when it happens. This is who can take stuff out. This is when you can take stuff out. This is when you can put stuff in. All of that stuff is outlined clearly inside that trust.
That's right. So, and again, remember, you can wear a couple of different hats, right? So you make the trust, and then that job ends, right? You've made the trust. Now and you've, not only have you made the trust, but you've reserved the right to change the trust, right? So it's your trust. You can do anything you want.
Wait a minute. You've reserved the right to revoke the trust?
To revoke it or to amend it.
To amend it. Right.
You can change it.
Right, because revoke implies that I'm blowing it up, right?
That's right. That's
so
right.
So not necessarily. I don't have to. So if I want to change it, that doesn't mean all that means is that I have that like you said, the flexibility that I can make amendments. I can change it. I can take this piece of paper out and I can write on the back and I can say, oh no, I could cross that out and say, oh no, look, this is we want to do something a little bit differently. And why is that important, Attorney Marston?
Well, it's important because when you put this stuff into your trust, you may do it with the idea that I'm not ready to get rid of it forever. I want it to go a specific place. I want it to go to my kids, for example. But in the meantime, I want the flexibility to not only use these assets, but I want the flexibility to change what happens with these assets because life happens.
I was going to say, could things change?
Things could change.
Could things change over the next 30 years?
Yep.
I don't know.
Maybe that in-law that you think is the greatest person on the planet right now may not be the greatest person on the planet right now, and you may have them in for some piece of the action, and you want them out. Or your kid gets divorced, or your kid has creditor problems, and you don't want them to inherit. So all kinds of crazy stuff could happen. So by making the trust and reserving the ability to amend it or to revoke it, you're giving yourself plenty of flexibility. So you made it, right? 3 people part of the trust. You made it. While you're alive, you're the beneficiary because there's the maker, there's the beneficiary, and then there's the trustee. Those are the 3 people.
Wait, I was going to say,
hold on.
No, you didn't tee up the trustee.
Hold on.
The trustee's the man.
Yeah. But again, you may wear multiple hats. So you made the trust. It's yours. You made it. You're the donor, the grantor. There's a beneficiary, right? And the beneficiary is you while you're alive, or your spouse if something happens to one of you. And then there's the ultimate beneficiary, right? That's leg 2 of the stool. And then there's the third part, right?
Yeah.
There's the player, right? The player is the one who has the on that list that's in the box, their name says only John can touch the stuff in the box.
Yeah.
Right? Here's what he's supposed to do with it, but only John can touch the stuff in the box. That's the trustee's job. Their job is to manage whatever you put in the trust. Now again, you can wear multiple hats. So you can give, this is going to sound a little weird, you can give yourself your stuff, but now you're giving it to yourself as the trustee, right? So you got to remember you're wearing a different hat.
So wait, let me just clear this up. So I'm just asking this question. So I can be the donor.
Yes, you can.
I can fill the box up with the stuff. I can be the beneficiary. It means I can have access and I can get that stuff if I need it, as long as it says so in here, right? In my directions.
Yep.
And you're telling me that I also can be the overall person in charge of that? I can be the trustee to manage that all while I'm alive?
You're going to put 3 hats on. Yep.
Come on, this is crazy. Why wouldn't I do that?
I know.
Well, why would I do it?
Well, you would do it because
this is the question. Why do it? What do I need this for?
So here's what the trust does. It allows multiple benefits, all right? The first benefit it allows for is it allows you, we just talked about, to be in charge of and control all of your assets while you're alive. You're not giving up any access, any control. If you have $1 million in your trust, tomorrow you can take all the money out and you can go to Vegas or you can go to the islands and you can spend it and you can do whatever you want to do with it. It's all yours. You're not giving up any control or any access. But if something happens to you, now, I'm not talking about you die. I'm saying something happens to you, you become incapacitated or unable to manage your affairs.
We're not talking about temporarily incapacitated.
I mean, you're out. You're out of it.
From that time you spent in the islands or in Vegas.
Right, that's right.
We're not talking about that 48 hours that you don't remember. Not
temporary incapacitation.
No.
This is full-time, legit, like you don't have the ability to manage your affairs anymore. Remember, you can lay out all the rules, right? So you have said in your trust, hey, as long as I can make the decisions and be in charge, I'm in charge. But if for some reason I can't make the decisions and I can't be in charge anymore, then I want my daughter to be in charge. Okay, so I trust her, and if I can't manage my whatever I've put in my trust box, then I want her to be in charge. Now, from a mechanic's perspective, this is what that looks like, right? Your $1 million trust is being managed by Main Effort Financial. You're out of the picture, right? So up until now, John's been dealing with you. Now you can't even pick up the phone because you're so incapacitated. And so what happens is your daughter calls John and says, guess what? You know that $1 million you're sitting on for my old man? Yeah. Well, he's incapacitated, and then you say, oh, he's in Vegas, and she says, no, this is different than that. This is more than that.
Well, I'll come over.
Okay.
I'll be right over. I'm gonna wake him up.
Yep. This is different. This is different. He can't manage his affairs anymore, and I need to step in and manage his affairs. So your response to her is, well, let's see. What does the trust say? Flip, 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 flip. You go through the paperwork. You say, oh, here it is. You are indeed next in line, right? You're the backup trustee. So I need a piece of paper. I need a letter from a doctor that says he's unable to manage his affairs, and that moves you up.
Now you have full access.
Now you're in charge, right? Now you're in charge. Now, that's the scenario. It's a phone call to John. John will tell you a couple of things that you need to chase down. Call the doctor's office. They get you whatever you need. That's a lot different than if you call my office and say, my dad didn't have a trust. He is unable to manage his affairs. He has $1 million in the bank, and I need to access that money to take care of him.
Whoa.
Because I'm going to say, first of all, assuming nothing else, but that's the situation, you've got nothing in place. The first thing we reach for is a fee agreement, okay? And we get the fee agreement where we write in the dollar amount, and we get the one that has the really long line, because we're going to be writing a pretty sizable fee number in there.
Because it's going to take a lot of work. Not because you're going to rip you off.
No, because it's a lot of work.
It's going to take a lot of time.
Because guess what? Because we're getting conservatorship lined up for you, right? And that's a whole nother process that, by the way, is infinitely more complex than calling John and saying to John, I just emailed you that doctor's note. Let me know if you need anything else, right? Because now I'm running off to probate court to get a conservatorship petition to let everybody know what's going on, maybe chase down some other requirements. Oh, and by the way, everybody gets to find out what's going on because I got to put a newspaper article in that says you need a conservator.
And
right?
by the way, this all doesn't happen overnight. And if Uncle Jay is incapacitated, he may need, first of all, he probably isn't going to be working. Second of all, you're going to need money, and he may need a whole lot of money, particularly if he has to go in for some sort of like extended care situation or something like that. And all this is going to take time.
Not only is it going to take time, and you're exactly right, but if you need to go somewhere, if he needs care, walking in the front door, the people who are guarding the door are going to say, by the way, does your father have resources? And your answer is, why, yes, he does. And then they start to open the door to let you in, and then you say to them, and once we get this conservatorship thing figured out, we'll be able to get you the money to get paid. And then the door slowly closes back again, because they're going to say, well, when you square that up, let us know.
Call us when you're ready.
That could take some time, and some of that stuff plays out in the news and gets a little weird, so we don't want to be part of that, right? So now, if you have done some pre-planning that we always encourage people to do, and all of your stuff is in a trust, and you have the ability to have already let the world know who steps in, this is a somewhat of a walk in the park, okay? And that means that, so you mentioned, why would you do a trust? So you do a trust because you can control your money. You've made a very clear glide path as to who would then get involved if you couldn't do something. And then the other part of this is, it's a private exercise.
Yep.
Nobody knows what's going on unless you have a vested interest in what happens in the trust. This does not play out in the public sphere. This is all private. And what you're doing is you're green lighting who is in charge if you can't be ahead of time.
So what you're telling me is that if I have a trust and I'm incapacitated or I pass away, and all of this can happen relatively smoothly, relatively quickly, so long as the trust document is in good shape.
Yes, correct.
So that means the access to the contents of the trust, should they be needed or for when they're needed, it's an easy path to get to that, right?
Yeah, well, it's the best of both worlds. I mean, it's you having access to all of your resources while you need them, or while you want them, or while you can be in charge of them.
Yep.
And then it's you laying out the rules that say, if I'm not able to do it, who gets the job? Now, years back, I had a scenario where I had a client who was very successful and had a substantial amount of money. And they were found in their kitchen. They'd been laying on their kitchen floor for 3 days. Something had happened to them. They were alone home. They didn't live with anybody else. They were single. And somebody figured out something was wrong and went over and found out that this person had had a medical event. And so the medical event sent them from their home, sent them to the hospital, and then from the hospital, we tried to get them to a rehab facility, which is where they ultimately ended up. This guy had a trust, and it had a sizable sum of money in it, all right? More than enough to pay for his care privately for a good long time. And the effort in terms of taking care of him was no heavy lift, because the people who needed to be able to say to the facility, hey, oh, by the way, and I have access to this gigantic pool of money so that my loved one can be taken care of without any hiccup in the plan, and this is all we need to do. I just need to find out where it's going. That was one of, for the longest time, that was one of my success stories, in the sense that this person had seamless access to care and seamless access to their resources to pay for their care.
And so let's say this person, and again, I'm not pretending to know this person, but let's say this person wasn't interested in having the whole free world know about how much money that they had, right?
Oh yeah.
Because it went through the trust, because his assets were kept in a trust, it's not that it had to go to probate court, and it's not that it had to become public knowledge to try and find someone to try and get conservatorship, if I'm not correct, if I'm not mistaken, right? So it remains private. Right, so the privacy piece of the trust is also very important for a whole litany of reasons, for creditors or whatever. But you have the ability to keep it out of probate. And what people don't realize, unless you've gone through the process, the probate process, is it's public. And everybody
it plays out, yeah.
And everybody can find out about it. And you live in a small town. You may not want that. You may not want to kind of have all of your laundry or your financial laundry out there.
And a funny sidebar to this situation, but the family had picked a very specific facility that they wanted this person to move into. And so I reached out to the business office at this facility, and I said, I represent this client. We're trying to obviously move him into a bed in your facility. This is where the family wants him to go. First question out of the business office's mouth, well, how are you paying for the care? Because it's going to be over $10,000 a month. And I said, oh, we have plenty of resources to pay for his care. And they said, well, how, when you say plenty of resources, how much? And I said, well, in the interest of protecting my client's privacy, I'm not going to give you an exact dollar amount, but let's just say this. We can pay privately for more than 5 years. Okay, that's how, and we could have paid privately for a lot longer than that, but I said, look, let's start here. Okay, that's really all you need to know, is you get 5 years covered. And they said, well, we need to know where the money is. And I said, well, don't worry about it. The client has a trust, and we can use the money to pay for them. This is going to sound crazy. The woman on the phone could not wrap her head around the idea that my client had a trust and had plenty of resources to pay for his stay. We ended up not being able to move the client into that facility, because the facility said, we're so used to people using trusts to keep money from us, and we don't want to get stuck with the client, that we're unfamiliar with the idea of somebody using it to pay for somebody's care. And it ended up being a problem, to the point that we said, look, we just got to look elsewhere, because no matter how many times we explained it, they couldn't wrap their head around it, right? So we had... Yeah.
It goes to the beginning of the show. We're talking about the difference between the understanding of what a revocable versus an irrevocable trust actually is. And that's probably what they were confusing.
That's exactly what it was. That's exactly what it was. So again, you've got three players, and you can be all three of the players, right? You can be the maker of the trust. You can be the trustee, which means you can be in charge of your own stuff and your own money and your own everything. And then you can be the beneficiary, meaning you can use your stuff, okay? And you can use it to benefit you. And then you also get to say, and when I'm not around, here's what I want to have happen to it. And the reason I'm harping on that is, if you're, when you like John works in this space all the time with clients, it's hard to wrap your head around the idea that you can be the same person in all three roles. But I say that because try to take yourself out of it and just think about it as three names. They just happen to be the same name, but it's three names with three different jobs, but you get to do all those jobs unless you choose not to do those jobs.
And for the most part, in the trust that we'll prescribe to people and say, this is, you probably want to have a revocable trust for all the the reasons that we discuss. but we'll describe it as that. Like, you're in charge of it. Don't be overwhelmed by it, right? You're in charge. It's all your bank account's name is going to change. Your investment account's name is going to change. It's going to say, to the Marston Family Trust. I mean, don't get hung up on that. It's still all your money. It's still there. You can still get it. There's no restriction on it. And just as Jay said, when you're alive, everything goes on business as usual. Like I said, we had a couple different document changes, but everything is business as usual. It's for when you either pass away or when you're incapacitated. That's when the trust becomes super important.
It's super valuable. And then we'll talk about one real quick issue before we go to a break, and then we'll come back and tackle the irrevocable part of this.
Let's go to the break, and then we'll talk about it.
Right, I just want one point I want to end on, and you mentioned it, and I want to build on it a little bit. By the way, don't wait until you're like 98 years old to put a trust in place.
We're thinking the same thing,
okay?
Because
here's the reason. Here's the reason. As you'll be shocked to hear this. The older you get, you're going to become a little bit more set in your ways. Okay, all right. And so then a guy like me rolls in and says, "Hey, I know you're 87 and you've been doing everything this way. Guess what? Change everything to the trust. Right? Let's do this." Earlier in the game.
Your checks aren't going to have your name on it anymore.
That's right, that's right. Let's do this earlier in the game so you get some familiarity with how the process works, and it's not going to rock your world because I'm coming in and saying you need to change that account to the name of a trust.
A guy like Jay comes in, who Jay is inherently a close talker, just because oftentimes his clients, if they're older, they may have a little bit of a hearing issue. Yeah, but he's like, he'll lean in. Let me tell you how you do this. All right. We'll be right back on Money in the Law. That's a good tee-up because I want to talk about that too.
Excellent.
We'll be right back. Money in the Law, My FM 101.3, Holliston Cable Access Television. We're on TV and radio. We'll be right back.
And we're back. Money in the Law, My FM 101.3. Jay Marsden, Marsden Law Group. He's John Drohan, Main Effort Financial. We're talking all things trusts today.
Revocable trust.
We're talking about the revocable wrapped up trust. The revocable. But I believe you had something you wanted to kind of end on there. A little nugget you were holding on to.
I want to. This is more than enough. This is important. So, in the context of the show, if you've been listening to the whole show, which thank you if you have. In the context of the show, we're kind of talking about what happens when people, in an estate planning issue, right? So if I'm planning my estate, right, and again, it's what's going to happen to my stuff. What is my intent of what's going to happen with my stuff when I pass away? And we all hope that that's when you're 110 years old and you're sitting on your front porch, right? However, unfortunately, there are times when people pass away much, much younger than that.
Sure.
So one of the really important in our practice and in your financial planning practice as well is when you're because estate planning isn't limited to old people. Estate planning is for all of us. All of us need to have some form of an estate plan. And when it becomes particularly important, especially for young people, is when, let's say, you're married and you have your first child. Right? So that estate plan is very important and important for different reasons, in the sense that, okay, yep, you may have some assets and you have people that are dependent upon you. So if something were to happen to me, if I'm newly married and we just have our first child, something happens to me, then of course my wife and my child have to be provided for. One of the things that is really, really important, and when we talk about estate planning, particularly with young couples, is what happens if in the very unlikely, very tragic, but very awful, but potentially could happen, if something were to happen to both of you.
Yeah.
So the idea in this case, in the case of a young couple, and if one of the spouses dies, then the other spouse will most likely inherit all of it. They'll get the life insurance. They'll inherit whatever monies they have. They probably have a joint account. They probably own their house together. So it's not a very complicated estate settlement.
No, very straightforward. It's paperwork.
Right. But what happens if both parents, God forbid, something happens to both of them, and you have a young child, right? So now, let's say they have assets, meaning let's say they own a house, and maybe they have equity in the house, they don't, but they own a house. Let's say they have life insurance, which hopefully that they do. So let's say each parent has $1 million of life insurance, both of them. So now there's $2 million that now, and let's say they've named that their child is the beneficiary, they've named their 6-month-old child as the beneficiary. Guess what? That doesn't matter, because whomever is going to be the guardian of that child, whoever has been named in their estate plan as the guardian is going to have access to all those assets if there's no documentation or there's nothing that says this is the way we want it to play out.
Well, they could eventually get there. I mean, again, you're playing out the scenario where if there's nobody, if you have a will that just says, here's who the guardian of our kids will be, right?
And let me, just to be clear, so the guardian isn't named inside the trust, right? The guardian is named in the will.
That's a will.
Yeah.
That's a will.
Yeah.
Thing.
So that's so whoever, and arguably that's the most important thing in that estate plan. Say, okay, so and I say this to clients. I'm like, okay, so yep, your money, if you did nothing else, your money would eventually find its way to your child in some way, shape, or form. Now, granted, there may be somebody else who has access to it, but eventually that it's going to head in that direction. Now, in your will, the most important thing is who's going to be the guardian, who's going to take care of your child if neither of you can do that. So,
but by the way, and just so you know, by the way, how that plan comes together is somebody gets named as the guardian, okay? Then somebody has to get named as the conservator, right? Or first of all, they have to get named as the executor of your estate, right? To go out and then collect all your stuff, right? And then now that they've collected it, now they have to give it somewhere, right? And you have a kid, and you have a kid who has a guardian, but you have nobody who can manage the financial assets that your child has inherited. So now somebody's going to get named as the conservator, all right? And we talked about it before, right? Let's get the fee agreement out because that's going to cost you some money. And by the way, guess what the conservator is more than likely going to do? They're going to go to the probate court and they're going to petition the probate court to set up an estate plan for your kid because you didn't do it while you were alive, because, you know, you were busy, the Pats were on, you got a lot going on. I got it. But at some point, someone's going to have to go do all the things that you could have accomplished much easier and much more from a cost-effective perspective, much better. And if you don't do it, you know, somebody else will do it and they will charge you all the way through to do this not because they're trying to gouge you, because it's a lot of work.
And they're going to charge you for it in the sense, they're the ones who are going to be making the decisions, not you.
That's right.
Because you can't make the decision anymore. So, what can I do? I can use, so if I know who my guardian is, I know who's going to be the guardian of my kids, who's going to take care of my children. What can I use that can control all of my assets and control them in such a way where I can say, okay, I understand that my guardian is going to need money to help raise my children. So guess what? Inside this particular thing that I'm talking about, I can carve out some money that can be used just for that. But at the end of the day, I want my kids to have my money. And so if I want my kids to have my house, or I want my kids to have my life insurance or part of my money, I want them to have it. But I don't want them to have it when they're 10 years old or when they're 15 years old. I want them to have it when they can manage it.
Well, not only that, here's when you don't want them to have it. You don't want them to have it when they're 18 years old, right?
That's right.
At 15, nobody cares, right? 15 years old, they can't rent a car, right? They can't go on spring break, right? They can't use their money to some nefarious purpose for the most part. You hope they can't, right? 18.
Nefariousm.
All bets are on. 18 years old.
That's right.
Hey, I need all my money. I'm an adult now, right? I can go.
Open my bank account.
I want all my parents' money, right? And I want to make a series of horrible, terrible decisions with their money because now I don't even know how to manage my vices, but I can afford them all.
Oh yeah.
So let the trouble begin.
So how can I fix that? How can I fix it? So my $2 million worth of life insurance, my house, my property, my bank accounts, all can go into what?
Oh, you're going to leave a set of instructions that go in a box that we also refer to as
Revocable Trust.
Yes.
Yeah.
Because remember, you control it all.
Christians even psych about that.
Christians like right now saying to themselves,
it's like revocable.
I need a trust. I think I need a trust.
I'm going to get a trust. I trust you guys. I need a trust.
It is, I mean, it's as a parent, you know, there are a lot of things we worry about, right? And we worry about how our kids are going to be while we're alive, right?
Yeah.
You worry about, you know, how's my kid's high school career going? Is my kid making good decisions, bad decisions? Are they hanging out with good friends, bad friends? All that stuff you worry about. So now, remember, you're not on the scene, right? And if you're not even there to oversee that part of it, again, at 18, the leash comes off and they're gone, unless you've made provisions. And you could set all the ground rules up, right? So you can say to my trustee, look, my kid doesn't get their money until they turn 25.
Yeah, so this is all inside those specific instructions. When we talk about these specifics, go ahead.
Well, you could say, look, and we have, at our firm, we have out of the box, without even asking, we set the parameters at 25 and 30. Your kid gets half of your estate, their share, your half of your, whatever your estate is, their share of your estate at 25, they get half. and at 30, they get the other half. Now, that's a starting point. That's a discussion point, right? And then what happens inevitably, depending on where the kids are, right? If they're really young kids, mom and dad come in and say, for the most part, unless there's been some experience in their life, my revocable trust with a 25 and 30 payout schedule, that works, okay? But then we have people that come in whose kids are older, and now they know their kids a lot more, right? Your kid is, I hate to say it, everybody, but your kid is different at 16 than they are at 6, okay? You'll know a lot more about them.
You'll see.
You'll know a lot more about their ability to manage decisions, make good decisions, make bad decisions. And you may say to yourself, I think I want to change my estate plan. I think I don't want my kid to get their money at 25. I think I want them to get it at 30 and at 35. Now remember, you're not going anywhere, but this is if something were to happen to both of you.
We always say this is in the very, very, I mean, statistically speaking, unlikely event that this is going to happen. So we're doing this, we're just like when we buy term life insurance. We are buying this in hopes that we outrun it. We are buying this so when my kids are 50 and 55, we're saying, hey, look at that. Remember that old trust? Oh, my God, Dad, you weren't going to give me my money till I'm 30, you cheap son of a...
That's right. And by the way, here's the other thing, too. If you have family members involved in your trust who are going to be making money decisions for your kid, what you want to do is you want to take out any subjectivity that might somehow negatively impact that relationship, right? Because if you made your brother-in-law or your sister-in-law the trustees of your trust, you don't want to leave it up to them to then now have to be the arbiters of when these things get paid out. It's much better for the relationship as a whole.
Have a different trustee.
For them to be able to look at the trust and say, look, I'd love to give you your money, John, Mary, whatever it is, but your parents, God rest their souls, have said that you are entitled to half of your money at 25 and half of your money at 30. I can help pay for school and I can do that, but I'm just following your parents' wishes. Don't get mad at me. I'm just the messenger.
Oh, wait a minute. So I have a question. So, and that's a great point, right? And then it allows you to say, look, I'd love to help, but I can't. So, but let's say we'll use the $2 million. So there's $2 million inside this trust from $2 million life insurance, $2 million, and you say, but also those instructions go on and say, okay, well, I like the 25-30. So half of it 25, half of it 30. So they're sitting around. But let's say, I don't know, that they're rolling around 18 and they'll say, I really want to go to college. You know, Uncle Jay, I really want to go to college. And Uncle Jay says, absolutely, you're going to college. We're applying now. You know, granted, their relationship in your mind, you hope that it's a good, loving, caring relationship, right? So at that point, it's like, hey, guess what? I just got my acceptance letter to Princeton. I really want to go. Oh, hey, wait a minute. I know your parents left you some money. Let's see what the trust says. And the trust can specifically say, oh yeah, you get half your money at 25 and half at 30. Unless you can take it for the following reasons.
That's right.
And there's a list of reasons, and the reasons could be to pay for college education, could be to buy a car, could be to go to trade school, could be to have
buy a piece of real estate.
Exactly.
As an investment.
Yeah, could be to buy that, based on these parameters. And you can spell it out in painful detail at the Marsden Law Group. They can sit there and they'll write out exactly what you want, exactly how you want it to be set up, and exactly how you want it to be sent out, and what those criteria are that will allow you to get money. And it's all clearly written inside that trust.
Well, and the nice thing about that is because you can lay out all the parameters, what you're doing is you're giving the trustee flexibility to say, I can pay for school, I can pay for a car, I can pay for an off-campus apartment. That's fine. Your experience is the same experience you'd have if your parents were here and able to write these checks, which they wish they were. But again, you're not entitled to your money. You don't get to raise your hand and say, give me my $1 million until at 25 I can give you half, and at 30 I can give you the other half. And that's what your parents wanted. But in the meantime, I can use it to keep everything on the straight and narrow.
It's not like they're writing you a check for $70,000. Say, make sure you send this to Princeton University.
No. Is that the invoice from Princeton? I'll take that. Thank you very much. That's right. That's exactly how it works, right?
Because that trust, you know what it has? It has a bank account.
Yep, that's right. It has actually a wire feature, and that money gets wired right to Princeton, right?
That's right.
So I think from a trust perspective, we use them all the time. It's a will substitute. Take the same wishes that normally go in your will, you put them in your trust, and then you get to make all the rules. You get to lay it all out, and more importantly, you get to change it. You can make any amendments that you want to make to it, because your life is going to change, things are going to happen. And by the way, the changes don't always have to be negative, right? The changes can be positive. You could say, look, my kids have great heads on their shoulders. I don't care if they get all my money at 22, because you know what? They got their act together, right? They're in grad school at Harvard. They know what's going on. Great. Here you go. All set. You can do that.
All those Harvard kids get their money early.
Well, they usually have a schedule. An advisor is managing that. It's a family issue. It's a family. We'll do that if anybody wants us to do that. But that's the idea. You can, your kid gets, and we've had that happen where the kid shows, a real aptitude for it, and the parents say, I'm not worried about them getting their money now. It's not a concern for me. Or I'm really worried about them getting the money now. Let's dial those ages way back. And
and then there's the other issue of why you may change it is, let's say there's young love and your child decides they're going to get married when they're 19 years old.
Oh, yeah.
And now there's another player that's involved, right? So if you say, well, if your trust says, well, if something happens to me, my kid's going to get get $500,000 at age 21, versus age 31, and there's a new spouse that you may not necessarily be, have that kind of faith and support and trust of that person, then you can make adjustments to that as well.
Well, not only can you make adjustments, and we'll wrap on this because we gotta kind of get a move on here.
Go to work.
But you can leave your money in what we call future trust.
Come on.
Right? So not only is one trust awesome, two of them is twice as awesome, right? So if you have real issues about your kid's ability to manage their inheritance, right? Your inheritance, or your money, that would be their inheritance, you can say, I leave my money to kid A outright. Here you go, John. And to Ted or Christian, I don't leave you your money outright. I leave your money in another trust. And guess what? Here's more rules, right? You can have income from the trust. That's all you can have. And the trustee can make discretionary payments as to whether or not you should get money.
Oh, it's too easy.
I mean, you can really play this out.
It's almost like the only way it would be better is if you had a souped up, super revved up DeLorean where you could actually travel in time and do this yourself. In other words, you can go back to the future or future to the back and actually do that stuff yourself.
Right, so you got to figure out, do you want your kid to be present Biff or future Biff? That's what you got to figure out. We'll leave it on that. You got to figure it out.
I paid for a tow all the way to your house, and all you got for me is a light beer.
That's right.
My favorite line from that movie.
Trust can help you out. Trust can help you out. So, okay, Biff.
All right. We got to wrap it up. We'll be back next week on Money and the Law. My FM 101.3 and the Hollis and Cable Access TV. Jay Marston Law Group, John Drohan, Main Effort Financial, both on Washington Street in Holliston, by the way.
Yeah.
Right?
A 5-iron from each other.
Yep. Five iron for you. You kidding me?
That's right.
That's nothing. That's a sand wedge for you. You can hit them.
Go ahead, muscles.
All right. We'll see everybody next week, Saturday morning, 9 o'clock. We'll see you next week.
Have a great week, everybody.